Good afternoon. My name is Michael Large. I'm the Elder Law Unit Head for South Carolina Legal Services. And today I'm here to talk to you about guardianships, less restrictive alternatives, and filing actions when necessary in probate court. Our office is often contacted by people who have concerns about allegedly incapacitated people. That can be family members, friends, professionals, anyone who has interaction with the allegedly incapacitated individual. And for today's purposes, I'm going to refer to that person as the AII, just for simplicity's sake. Usually the clients are seeking legal advice because of legitimate concerns and a desire to protect that allegedly incapacitated individual. You should, however, investigate all options before filing a guardianship case, because doing so is going to set off a chain of events with serious and oftentimes unintended consequences. You have to remember, as adults, we have the right to manage our own affairs and deal with important decisions affecting our life. For instance, voting, marrying, how to raise our children, what to eat, medical decisions, where we want to live. And that's just to name a few. When an individual needs help making decisions in their lives, that person will usually examine his or her own options and seek necessary assistance. Think of it, we do this every day. Making healthcare decisions, getting automotive repairs, preparing our taxes. I don't know about you, but I seek help when I'm making those decisions. The same applies to adults with disabilities and the elderly. They're also able to manage their own affairs with the appropriate services and support systems. Because guardianship is going to impact many aspects of their life if that's necessary. It can remove or restrict your ability to make important decisions for yourselves, such as where to live, who to see, and what to do. Can't stress it enough, guardianship is only appropriate when the alternatives have failed to provide necessary protections for the incapacitated individual and legal authority is needed to make decisions regarding health care, medical treatment, appropriate placement, and to protect the individual. In other words, guardianship is a last resort. As of January 1st, 2019, Article 5 of the Probate Code has been revised and new laws go into effect. There are significant changes to the South Carolina Probate Code, and we're going to address some of those key changes today. So what are some conditions leading to incapacity? Some examples would be diseases such as mental illness, dementia, Alzheimer's, psychological and psychiatric disorders, intellectual disabilities such as autism. It could even be drug and alcohol abuse, personal injury, or similar causes. Everyone is affected differently by these diseases and conditions, and just because a person suffers from one of these conditions does not necessarily mean that they are legally incapacitated and require guardianship. In older adults, deciding if and when the right time to file for guardianship can be far more challenging. When seniors show signs of dementia, memory loss, and other cognitive impairments, it can be hard to determine what might be old age and forgetfulness versus signals of something much more serious. Studies have shown that people with greater self-determination are healthier, more independent, well-adjusted, and better able to recognize and resist abuse. Adults suffering from a progressive condition that results in cognitive impairment are at risk of having their right to self-determination effectively erased by a guardianship order. So what is incapacity? The definition under the new South Carolina law defines incapacity as the inability to effectively receive, evaluate, and respond to information or make or communicate decisions such that a person, even with appropriate, reasonably available support and assistance, cannot A, meet the essential requirements for his physical health, safety, or self-care, necessitating the need for a guardian, or B, manage his property or financial affairs or provide for his support or for the support of his legal dependents, necessitating the need for a protective order. So we have to consider the alternatives. As an attorney or a concerned family member considering a guardianship action, you need to investigate and attempt less restrictive alternatives available to the AII before filing the legal action. There are statutory requirements compelling consideration of less restrictive alternatives. For instance, in the petition, it now requires you to identify which rights the alleged incapacitated individual should retain. Any no answer requires an explanation as to why. With regard to financial affairs and healthcare decisions, the petitioner must explain why less restrictive alternatives to guardianship or conservatorship are not appropriate. Additionally, the probate court is now required to, and I quote, exercise its authority to encourage maximum self-reliance and independence of the incapacitated individual and issue orders only to the extent necessitated by the incapacity of the individual. So as a petitioner seeking guardianship, you have to prove, first, that the alleged incapacitated individual is unable to access information or communicate a decision, that they are unsafe or their property is unsafe unless there is a guardian appointed or a protective order issued, and appropriate, reasonably available supports and assistance will not mitigate the need for a guardian or protective order. In other words, the appointment of a guardian is necessary to provide continuing care and supervision of the alleged incapacitated individual. And finally, the new evidentiary standard is that the probate court may only appoint a guardian if clear and convincing evidence shows that the individual is incapacitated. That's a very high standard. On a football field, more likely than not would be the 51-yard line. And reasonable doubt, you'd be on the goal line. Clear and convincing evidence is what I would consider to be in the red zone, about the 20-yard line, somewhere in there. And that's quite compelling evidence, indeed. So the American Bar Association has developed a practical tool which aims to help lawyers identify and implement decision-making options for persons with disabilities that are less restrictive than guardianship. Practical is an acronym for 9 steps for lawyers or those that are trying to represent themselves to identify these options. The ABA intended this to blend in naturally with the case interview process. In my experience, however, I just try to keep the various considerations in mind while letting the flow of the interview proceed naturally. So practical. P stands for presumed guardianship is not needed. R is the reason. Clearly identify the reasons for concern. A is ask if concerns are temporary or reversible. C, community, are the resources available to help. T is for team. Is there a team to help make the decisions? I is for identify. Areas of strength and limitations in decision making. C is for challenges presented by supports and the supporters. A is appoint a legal supporter or surrogate. And finally, L, in our case challenges in this case. It's not really an issue in this case in terms of her supporters. She has, it seems to me, to be a caring, loving family. We haven't asked about any of her friends or neighbors or what they can do, and that would be one thing to investigate. We also don't know if Mary is seeing other doctors for other reasons where she can get second opinions as to her medical capacity. A is for appoint a legal supporter or surrogate. An agent under a power of attorney or a healthcare power of attorney, a trustee, maybe a representative payee for her Social Security retirement benefits. Could any of these appointments meet Mary's needs? That's the question. Well, Mary could appoint her daughter as an agent under a power of attorney to help with bills. The South Carolina Adult Health Care Consent Act might be useful for communicating with Mary's primary care physician, or if possible, she can execute a healthcare power of attorney naming Jane or her brother as the agent to help with those decisions. L, finally, is limit any kind of guardianship order that might be needed. So in Mary's case, there are substantial supports and assistance, and guardianship does not appear a proper course of action at this time.